Okay, welcome everyone. We'll start lesson 3. Today lesson will go through LO3 learning outcome 3. Understand how European Union laws are enforced. So that's we'll go through. So today lesson key are indicative contents. We'll go through the doctrine of supremacy and direct effect on dualist, constitutional, EU and the member state and their powers and subsidiary. So there are a lot of keywords, but overall our discussion will address all. If you have any question, please drop me email. This will be also carry on in LO4 as well, between our discussion. So we'll overlap. So that will go through. So first of all, we have a 3.1 assessment criteria, evaluate the doctrine of supremacy. So in order for EU law to work, it need to have a priority in the legal system. So what we need to do, if you want to be implement, so we need to be a priority in the legal system of the member state. So doctrine of supremacy means where there is a conflict between EU's laws and the domestic law. So EU laws say different and domestic laws say different, so that can be a conflict. Then EU laws wins. So that's why the UK government left the Brexit, because the EU laws can be have the supremacy over the UK laws. So that was a huge, discussion about the laws ECJ. Supremacy is not mentioned in EU treaty. So that's other area, in the EU treaty is not mentioned the supremacy. It was created by CJEU. The principle of the supremacy is highlighted in the case of Costa and Enel. A dispute arose as to whether Italian courts were obliged to apply the domestic legislation or if the preliminary ruling from the CJEU would have a primacy. So CJEU held the community laws must be prevail over the conflicting rule of national law. So that's this case was quite popular. Even if enacted subsequently to the community rule, supremacy are still further when the CJEU held that the EU laws were the supreme even against the domestic law was passed that conflicted with the previous EU norms. That's other problem. In international is handled Croft, the CG held the EU laws took the primacy over the many types of domestic law, including the constitutional laws. So the net effect is the CJEU confirmed that the EU law is supreme in almost all circumstances. So you pass something like we have a GDP, we have environmental laws, we have a human rights. So these are all the the EU's are the supreme than the UK laws. So that's was a bit issue as well when the UK government and they not there is a conflicting. Okay, the legal system have to be managed the extension between the EU supremacy and their claim to the national supremacy. Different member states had varying level of difficulties in accepting the principle of supremacy. So given the member state have a different constitutional traditional, that's the problem. It's not just the people movement. The difficulty with EU law supremacy in the UK is that the UK constitution places great importance on the principle of the preliminary sovereign state. So essentially, the parliament has the right to make or unmake any law, according to the way 1955. The UK adopted the dualist approach to EU domestic relationship. This means EU laws only has effect when enacted by the domestic act of parliament, become a local law. So European Community Act 1972 was the domestic act adopted to the UK. The House of Lords, considering the approach of the court, must take when there is a conflict between EU laws and the domestic law. So there has a direct conflict between EU treaties and the domestic law, Merchant Shipping Act 1988. The Lord held the European Community Act 1974 provided the supremacy of the EU laws where there is a conflicting with the UK law. So in effect, the court must apply domestic legislation where such conflicting exists in that case. The Lord Bridge held that it was the duty of a national court to choose EU law over the domestic law. So this appeared to be radically reformation of the nation's parliamentary sovereignty. So however, some scholars like Eliot 2010 believe that the national laws still have the priority because the UK could withdraw from EU anytime, repealing the Act 1972. Okay, guys, if you have any question, you can drop me email on my email address, anjum@ukversity.co.uk, so I can further we can discuss. And make sure please join the next lesson. Further, Miller and Secretary of State existing the EU 2017. Okay, so the Supreme Court concluded that the court duty to display the domestic legislation did not apply to the legislation that altered the constitutional status of EU institutions or the EU laws. Okay, the Supreme Court concluded, so this, the one has therefore the duty to display not absolute. The argument was further bolstered by the European Union Act 2011 when declared that the EU laws only took effect in the UK because the continuous existence of 1972. Yes, so 1972 Act. So that's, further we need to look around as well. So we can discuss, we can find 1972 Act and further we can look around in details as well if you want, guys. This is not an entirely convincing argument. While it was theoretically possible to repeal the Act 1972 Act, there was no political appetite to do so until after the 2014 when the memorandum or momentum for the Brexit gathered pace. The UK courts are able to reconcile EU laws with the parliamentary sovereignty as the UK adopt dualist approach to implementing the law into domestic legal framework. So that was, that was the key. Okay, so that's the UK courts are able to reconcile the law with the parliamentary. So that's we need to be look around as well. Further, in next we have what about other member state think other than the UK. So Germany at the first, the highest German court refused to recognize the supremacy of EU laws over the Germany constitution law. So in Slung, the court held that there was a conflict between EU laws and the domestic constitutional law. Then the constitutional law was the preferred. So in the second, the German Constitutional Court softened its position. It concluded that there was a conflict between the German constitutional law and EU law. Domestic court would not interfere as long as the EU laws provided equal protection. So as the CJs, European Court of Justice, that's developed the fundamental right of doctrine. The German Constitutional Court could no longer give the primacy to the domestic laws that conflicted with the EU laws. So at the right, this doctrine could protect the right from the German constitution. So, however, the European treaties in German court is further stated that it is intervened to assess compatibility of EU laws with the German constitution. And the effect of so the German court not control whether the German will defer to EU laws under the certain condition. However, these conditions narrowly than those in the UK. So where the UK, although the 1972 Act give the primacy EU laws and the German give primacy to the EU laws under the strict condition. So that's the conflicting information, and that was the big issues. Okay, then we have 3.2 compare and contrast the treaty regulations and directive. So regulations are being the legal force throughout every member state, interforce set date in the member state. So if food information to the consumer regulation one of directive lay down the certain result that the must be achieved, but each member state is free to decide how to transpose the directive into the national laws. So that can be members can be okay. Okay, so then directive, those mean the decisions are the EU laws are relating to the specific cases and directed to individual are the several member states. The companies are the private individual. There are the binding of those whom they are directed. So that's, further we can read these through these, the cases in those, and we can compare and contrast as well. Okay, every action taken by the EU is founded on the treaty. These are the binding agreement between EU member states, countries set out EU's and the agreement between EU member countries and set out the EU objective, the rules for EU institution, how decisions are made, and the relationship between the EU and its members. Treaties are starting point for EU laws and are known in the EU as the primary laws. The body of law that come from the principal objective of treaty is known as the secondary laws and include the regulation, directive, decisions, and the recommendation and opinions. Anybody any question? Okay. The legislative act are adopted and the following one of the legislative procedures set out in the EU treaty ordinary are special. So non-legislative don't follow these procedure and can be adopted by EU institution according to the specific rule. So the EU can pass the law only those areas where the member have to be authorized to do so. So via EU treaties, areas of EU action and adopting EU laws. Okay, so EU treaties lay down the objective of the European Union, the rules of EU institution, how decisions are made, the relationship between EU and the member treaties. The EU treaties from the time to time amended to reform the EU institution and give the new area of responsibility. They also be amended, allow the new EU countries to join. So the treaties are negotiated and agreed by the all EU countries and then ratified by their parliament and sometime following the referendum. Regulations are legal acts that apply automatically and uniformly to all EU countries as soon as they enter into force. So without needing to be transposed into the national laws, and these are the binding in the okay. So national laws there are binding. So that we need to look around. So directive require the EU countries to be achieve a certain result but leave them free to choose how to do so. EU countries must adopt the measures to incorporate them into the national laws transposed in order to achieve the objectives set by the directive. So national authorities must communicate these, the measures to the European Commission, and transposition into the national laws must take place by the deadline set the directive. That's generally within 2 years when the country does not transpose directive and the commission may be initiated infringement proceeding. So that's we need to be okay guys. Next we're looking the decision. The decision shall be okay. Decision is a binding, is entirety, and the decision are the specific those to whom to be addressed. Recommendation can be drawn the EU institution to make their views the known and suggestion in line to the action without imposing any legal obligation those whom to be is addressed. Opinion is and the instruments, and delegate act are the act, the legal binding act. And then we have a commission, opinions, delegate act, and implement act. So implement are the legal binding act, that enable the commission under the supervision committee that we need to be look around. Okay. Any question, anyone? Those are listening, please, if you have any question, you can drop me email as well. So 3.3, accept the direct and indirect effect. So principal interpretation, where the court and the member state of European Union must interpret the national law, particularly any implement EU's directive, as far as the possible in the manner that is consistent with the provision of EU, even they don't have direct effect. So also known as the principal or harmonized interpretation. Okay, the ability of the European Union legislation to be enforced by individual in the court member state, the provision EU laws may be capable of the direct effect, and it is clear and precise, unconditional, and does not give the member state substantial discretion in its application. Direct effect may be vertical, that is, EU legislation can be enforced against the state and the emanation and the states, such as nationalized industry or the privatized utility. So horizontal, there may be enforced against another individual. So each EU treaty provision, the regulation decision are the capable both in the vertical and horizontal direct effect. Directive are the generally only be vertical direct effect. So directive have the direct effect, and there is a further requirement. So direct effect related to but different from the concept of direct applicability. So see also indirect effect. So not directly but indirectly is effective. So principal interpretation, where the court member state European Union must be interpret the law, particularly any implement the EU directive as possible as the manner and in the consistent with the provision of the EU laws. That's direct effect. Okay. Then next we have that's what the direct and indirect. Next we have 3.1. If you want to work towards merit, compare and contrast the proceeding action infringement against the state member state can be. So European Court is um, Court of Justice side is Luxembourg. We know the 28 members and EU Commission and also judiciary. The reason for the European Court of Justice is important. These had the two essential cases on where the ruled over the time. So Van Din lose in 19 Dutch transport case, in which the rule over the time, and thus the government increasing the duty of the product imported in the Germany as the ECJ rule the European Community Constitution, a new legal order consisting of all the member states, their national, all whom they are covered by the law, and they are backed by the Costa versus Inel. That's 1964, which we discussed in 3.1 as well. Court ruled the member state has definitely transferred the sovereignty laws to the community, which means the union laws could not be overridden by the domestic law. Okay, the Commission identified the possible infringement of EU laws on the basis of own investigation, the following complaint from the citizen, businesses, and other stakeholders. If the EU countries concerned fail to communicate the members that fully transpose the position directive or does not rectify the suspect violation of EU law, the Commission may be launch a formal infringement proceeding. The procedure follow the number steps laid out in the EU treaty, each ending with a formal decision. The Commission send the letters to the formal notice requesting the further information to the countries concerned, send the detailed reply to specific period, usually 2 months. The Commission conclude that the countries in failing to fulfill its obligation. obligation under the EU laws. It may send the reasons, opinion, and the formal reasons to comply EU. To explain why the Commission considered the countries is a breaching EU laws and also require the countries from the Commission in may taking, the specific. So that's guys, really, need to be. So if they despite, the court judgment and the country still doesn't rectify the situation, the Commission may refer countries back to the court. So referring EU country to the court to the second time and the Commission purpose to the court impose the financial penalties, either lump sum. So that can be, the to be. So that's why the country need to be fulfill the requirement. And information about the Commission decision and the infringement is available online too. You can search further if you want to, and I included the report which we can read. So guys, this is the report on the infringement adopt calculation methodology, the financial sanctions. So please, that's is good to be read in your own time. That also help us to further clarify our concept. So that's all today lesson. So today we discuss about EU treaties, treaty laws. Yes. And those people, due to any reason they not managed to join, please make sure just read and go through, and I'll see you and speak you in the next lesson during our lesson 4, which will go through LO4, and I'll speak you. If any question, please drop me email at my email address, anyum@ukversity.co.uk. Thanks for listening and joining, and I hope to speak you all during our next lesson. Thank you. Bye bye.